A very good morning to everyone present here. For today's session, we have Ms. Manasi Bhushan ma'am. Ma'am is an advocate practicing at Delhi High Court. Her practice lies in the field of civil, criminal, commercial, matrimonial, labor and service, negotiable instruments act matters, and arbitration. We welcome you, ma'am.
Thank you. Thank you so much. Good to see some interns who are wanting to attend the session on a Sunday morning as well. And today's topic, as you all would be knowing, is how to draft a PIL. Now, before we begin with this session, may I have an idea as to in which year are you all?
Basically, they are from their first years.
Okay, first year. So before I start with what is public interest litigation or how to draft it, let us just understand what is the concept of PIL. Have you all heard about what is PIL? Now, this is an interactive session. You need not just listen it in a lecture form. This is an interactive session. Feel free to speak up. You can unmute yourself. If you want to switch on your videos, you may do that. And then answer. So what is PIL? Anybody? Okay. Okay, so let me just start with my PPT as well. Can you all see the PPT?
Yes, ma'am.
Yes,
ma'am.
Great. So, Sushri Swapna Mishra, what is PIL? Since you had said yes, I'm believing you are there and it's not just the computer who's attending the session. What is PIL?
Ma'am, public interest litigation.
Yes. So what do you mean by public interest litigation? If we see these three words, what do you think? What is this? Something to do with public, something to look at their interest and with regard to any litigation matter? Am I correct?
Yes, ma'am.
Yes. So what is PIL? PIL is basically public interest litigation. What does public interest litigation means? Now, where is this concept taken from? This is taken from the American jurisprudence. And what does it say? It is basically designed to look at the interests of the public. Now, not everyone is belonging to a privileged section, isn't it? Not everyone can have an access to a lawyer, have the resources. Say if somebody is living in a village or in a tribal area, that person cannot leave behind his daily work and go to, say, a lawyer, say in a city, travel all the way, bear that expense, find a lawyer, trust that lawyer, sign, look at all the documentations, approve that, and then go to the court on the dates of hearing. So it is not really possible for somebody to take all much of, hassle that ways. So in order to protect their interests, so what do you think? Does the society say that, okay, fine, since they are not vigilant enough or they don't have any resources, let them be at howsoever they want to be. We'll not look at them. Do you think India is a socialist country or India is a capitalist country? Quickly. Do you think India is a socialist or a capitalist? You can put in the chat box also your answers. I will look at the chat box also simultaneously. Do you know what constitution is? Have you heard of the word constitution? Yes or no? You are students of law. I believe you would know what constitution of India is. Come on, this is an interactive session. You all have to participate. This is not a lecture. I'm not a teacher over here.
Secular and socialist countries.
Very good. It's secular and socialist country. So socialist means it will look at the interests of all the people and not just one particular segment of the society. Right? So if somebody is poor, somebody is underprivileged, somebody do not have access to the resources, that person is also protected by the law, also has access to law and courts of law. Article 14. What is Article 14? Anyone knows? I know you all in your first. Law. Equality before law. Wonderful. So equality before law says that everybody has access to law. Everybody will be treated equally in the eyes of law. So when I say access to law means that if suppose there's some discrimination happening or suppose there's some fundamental rights violation happening of one particular segment of the society, that person within that section, one person from that section or even otherwise, anybody else who's not belonging even to that section of the society can go to the court and say that kindly give justice to these people. They are being deprived of their rights and law is violated over here. So in order to protect certain classes, even if those people from that class are unable to come to the court, are unable to represent themselves before the court, anybody who's public spirited person any individual, any organization who is willing to look after the rights of somebody else, who's willing to take up a fight in the court, who's willing to represent them in the court, that person can file a public interest litigation. Courts will not shun that person, saying that you are not even belonging to that class. Let us take an example. Suppose if there is a school in a village wherein there is gross fundamental rights violation, girls are not allowed to study in that school, and all the boys from that village are only allowed to study in that school. Now, if I see this scenario, I went on a vacation, I went to that village, I went for a trip, I saw this is happening. I asked the people around there, they said, whatever is happening, we are not bothered, we are busy in our lives, we have to earn money, we don't have time for courts and lawyers. So then they are not taking any step against this gross violation. Isn't this violation of Article 15? What is Article 15? Anyone knows?
Discrimination on the ground of religion, race, caste, sex, place of birth.
Very good, very good. So discrimination on the basis of religion, caste, sex, place of birth can be on any basis. So prohibition of such discrimination is given under Article 15. So as I said in my example over there is discrimination happening. Girls are not being allowed to go and study in a school. And those girls are also not willing to go to the court because they say our travel would be so expensive that we won't be able to afford a lawyer, afford the court proceedings. So in that case, when I come back from my vacation, I file a public interest litigation in the Supreme Court saying, or in the relevant High Court, saying that this is against the principles of law. This is violative of the constitutional fundamental right guaranteed to everybody in that village, and kindly look into the matter. The court should not say in that scenario that you do not belong to that village, you are not one of those girls, and therefore we will not look at this matter. Court will not say that. Court will say this is in public interest. This is being looked after at one section of the society. Can be 5 people, can be 10 people, can be hundreds and crores of people also. But court will certainly entertain it. So let us again see what is PIL. It was designed to provide legal representation to previously unrepresented groups. Now, who can be unrepresented groups? Either they do not have resources, financial resources, like they are poor, or they are racial minorities. What can be racial minorities in our, or let's say minorities, let's just forget racial for a second. What are minorities? Are transgenders minority in India? Yes or no?
Yes, they are.
Yes, Monsji say, I'm sorry if I'm pronouncing your name incorrect. It's Mon.
It's
How do you pronounce it?
Monsige.
Monsige says yes, they are minority, and he is absolutely correct. If you see at the population, they are male and female, and the transgenders or LGBTQI community are very less for that matter. So yes, they are minorities. Unorganized consumers, or say unorganized sectors. Your domestic help, is that an unorganized sector, or is there any rule and regulation as to how will you keep a domestic help? How much wages will you pay to the domestic help? Or is there a union for domestic help? What do you think? It's an organized sector or it's an unorganized sector?
Well, it's an unorganized sector, but it is being handed over with their unions, as I think.
It is an unorganized sector, and sadly, currently there is no rule or regulation which regulates as to who can be kept as a domestic help. Of course, there's prohibition of child labor act, which tells in as to certain age limit below 14 years, you cannot keep a domestic help. But that ways, if suppose there's gross fundamental rights violation taking place, in that scenario, even if I'm not a domestic help, I go to the court, I being a lawyer, I being a layman, civilian, completely unrelated to that sector, can also go to the court, knocks the door of the court and say, kindly give them justice because they are unable to come to the court. Therefore, I am requesting the court to look into the matter. Citizens who were passionate about environmental issues. By any chance, have you heard of MC Mehta?
Yes, ma'am.
Yes, MC Mehta was a great environmental lawyer, and he used to file a lot of PILs in order to safeguard the environment of various, not just one city, not just one state, overall country. He was filing PILs. One of the examples you must have studied is regarding Taj Mahal. What had happened to Taj Mahal? What's the color of what is the color of Taj Mahal?
White.
White. Very good. But because of pollution in nearby industries in Agra, the color of Taj Mahal was started to deteriorate from white to yellow. And because of that, MC Mehta filed a petition and he said that all the industries work should be stopped nearby Agra and near that vicinity, because the color of one of the wonders of the world should not become bad and it should not deteriorate. And therefore, looking at that PIL, Supreme Court also granted a relief and said that yes, industry should shut up. So this is the concept of PIL. Now let's look at as to some of the cases wherein PIL had worked in. What had happened in this? This is Janta Dal versus HS Chaudhary. What did the court say in this? It said PIL is a legal action started in a court of law for enforcement of public or general interest, where the public or particular class of public has some interest, including pecuniary interest, that affects their legal rights or liabilities. As I gave multiple examples, easy examples right now, Janta Dal judgment says as to what is PIL. PIL is basically going to the court. Why are you going to the court? In order to safeguard the interests of certain classes or say one section of the society. Why are you protecting them? You are looking either at their pecuniary benefits, either this is say regarding minimum wages, which is to be granted to the laborers, either looking at their pecuniary. Pecuniary means relating to money, or either at their fundamental rights, that they should be treated in a certain manner, that they should be given certain rights just like other citizens are given. And who can approach to the court? Not just those people whose rights are violated, even otherwise who's not even related to that matter can also go to the court, and he will be also equally entertained in this matter. Yes. Now let us see what's the dictionary meaning of PIL. It says public interest. Let us see what does the word public interest means. It means that something which is relating to public or community at large, wherein some pecuniary interest is related, or it can be any interest, their legal rights or liabilities are affected. An interest is shared by citizens generally in affair of local, state, or national government. It can be at any level. It can be at district level, it can be at state level, it can be at international level also, national level also. What is the significance? Why are we studying PIL? Why does PIL matter? What will happen if we will not study about PIL? Will it make some difference? So let's see what are the advantages and significance of PIL. One is it gives access to the court to common people. Now, when I say common people, I am particularly not focusing on the people whose rights are violated. It can be you also. Even though you are not yet a lawyer, you are still a student, you can file a PIL through, say, a lawyer or by yourself. You can write a letter to the Chief Justice of relevant High Court or Supreme Court saying this is the matter which should be looked into. It is violative of fundamental rights. It is violating those persons' interests, say with regard to finance, say with regard to moral duties, say with regard to their own obligations, which is being not adhered to. So for that, you can file a PIL. It helps in judicial monitoring of prisons, asylums, protective homes, etc. People who are prisoners, who will fight for them? Prisoners, of course, have access to lawyers, no doubt about it. But suppose no lawyer is willing to take up that matter. They feel afraid because some action will be taken against them. So even if a prisoner from jail writes a letter to the Chief Justice saying that we are beaten up in prisons, saying that the working conditions over here is bad, habitation conditions over here is worst, there is no light, there is no ventilation, people have diseases, there's no one to look after them. So kindly look into this matter. Court, upon receiving that letter, can treat that letter and convert it into a PIL. There are instances for it. We'll study that in some time. And last is implementing judicial review, which accelerates balance between law and justice. What is judicial review? Anyone knows what is judicial review? You have heard the word judicial review? You have to be interactive. You can't just
like some judgment has been reviewed, or that judgment has been reinstated or re-looked into, sort of.
You are
I don't
partially correct, Mansage. Judgment, when a judge looks into a matter and he tells the legislature that kindly look into this aspect, kindly make a law. It is called as judicial activism and review. Ideally, judges' work is not to make the law. Judges are not here to make the law. Judges are here to implement the law. Whatever law is there, they have to see whether that law is being correctly followed or not, and accordingly punish the offender. That is the work of the judge. Legislature's work is to frame the laws. It is not to implement the law. So that's why we have three pillars of democracy: legislature. What are the other two?
Executive
Very good.
and judiciary.
And judiciary. Now the fourth pillar sometimes is said as media also.
Media.
Yes, good. So judicial review is basically looking at certain matters, and it also comes under the ambit of judicial activism, where judges' responsibility is not to make laws, but it will frame some guidelines. It will put in some of its own opinion that a law should be made wherein all these aspects should also be looked into. So we'll also see some cases with regard to that. That is called judicial review, and it helps in balancing law and justice. It helps in looking whether law is being properly framed or not. If a law is framed, whether it is constitutionally valid or not. Very recently, a burning issue these days is regarding marital rape. Anybody knows what is the issue going on these days? Delhi High Court and Karnataka High Court had recently held that marital rape is, anyone knows?
Is punishable.
Is punishable, is a rape. So there was a split verdict in the Delhi High Court. Justice Rajiv Shakdar and Justice Hari Shankar. One of them said that marital rape is rape, and another said that marital rape is not rape. If a husband is committing if husband and wife are having non-consensual sexual intercourse, then it will not come under the purview of rape. It is permissible. Because under section 376 of your Indian Penal Code, there is an exception which says that any sexual intercourse or sexual acts between a husband and wife will not come under the purview of rape. So there is this debate going on. So in case, let us assume the matter is now referred to Supreme Court. If Supreme Court says that yes, this is rape, so Supreme Court will not change the exception under 376. Supreme Court will direct it to the Parliament, kindly relook into the matter and frame certain new guidelines, whether sexual intercourse, if forcefully done between husband and wife, will it amount to rape or not. So that way then Parliament will make the law. Supreme Court can only provide in some opinion or some guidelines to the Parliament. Yes.
Ma'am, can I ask a question, ma'am?
Yes, Mansuj. Yes.
Ma'am, the consent or non-consent comes under any of these factors, like if consent is given or is non-consent is there, or anything sort of. And there is also one question, like non-performance of sexual activities can also be taken as a ground of divorce in cases of spouse. Okay. So can you just give light on that?
Yes, so I'll quickly answer this, though this is not related to PIL. So firstly, with regard to consensual versus non-consensual, rape under 376 clearly says a man who commits any of those acts are also mentioned, without the consent or without the willingness of the girl or woman, whatever. So then it is rape. So consent is a very essential ingredient of rape, willingness and consent. There's a difference between consent and willingness also. Willingness is the person initiating, is called, that act will be said as willingness. And consent is even if you're not initiating, you agree to that act, then that will be consensually done. So for rape, yes, consent is utmost important. That's why the entire issue of marital rape is currently in question. That whether if husband wants to have sexual intercourse, if wife does not want to have, then is it forcefully done on her because she's not consenting to it? She's also not willing to have it. So then in that case, it should come under the ambit of rape, or it should come under some other ambit, or it should not be considered as rape at all. First is this. Second question, what you asked is, what was that? Mansuj?
Second question was that sex is also ground of divorce. Like if there is no sex between or no intercourse between the spouse, that can also be a ground for divorce.
Yes. So under section 13 of your Hindu Marriage Act, there are a lot of grounds stated therein. It will come under one of the grounds wherein say either if any of the spouse is impotent, impotency is a ground for divorce. If suppose impotency till that end, it cannot be proved, and it can be said that either of the spouses have denied cohabiting. Cohabiting means having sexual relations with the other spouse, then it will amount to cruelty. It will also amount as a ground for divorce. But of course, this has to be proved in the court that, and such things are very difficult to prove. But there are people who have texted or have sent an email or have time to time expressed it to their family members. Those family members will come in and depose before the court. So yes, this will amount as a ground for seeking divorce. Yes, now we'll come back to PIL. Once that answers your question.
Yes, thank you.
Yes. Now the question comes in, can PIL be filed in district court, in high court or Supreme Court? What do you think? What will happen?
High Court and Supreme Court.
Very good, Sushri. So only in High Court and Supreme Court. What have you heard of writ petitions by any chance?
Yes, ma'am.
Yes. What is writ petition? Ruksha? What is writ petition? Yes.
Ma'am, if any fundamental rights are going to be violated, then we can file writ petition.
Very good. So when
Ma'am,
yes, Ruksha.
ma'am, that higher authority or higher courts directs the lower courts to like look after some matters and to stop them. Like
Yes.
we have like mandamus and habeas corpus.
Yes. Very good. Very good. So the writ, what you explained just now is regarding writ of certiorari. By what the higher court telling the lower court as to by what authority have you passed this judgment, or calling the records from the lower court to the higher court and then looking at the matter itself. There are 5 types of writs: mandamus, habeas corpus, certiorari, quo warranto, and prohibition. So currently we are not going into writs, but PIL is filed as a form of writ. Public interest litigation petition is filed as a form of writ only in High Court and in Supreme Court, not in district courts, because district courts a suit can be filed, district court a petition, a claim can be filed, but there is no enforcement of fundamental rights in the district courts. It's only there under Article 226 in High Court and Article 32 in Supreme Court. These articles, of course, are given under Constitution of India. So PIL is basically an extension of writ jurisdiction, as I said, in Supreme Court under Article 32 of the Constitution and before High Court under Article 226 of the Constitution. Now let's see what is the form of PIL. Can I write a letter to a judge and say that this is the violation taking place? Students are not being allowed to take exams online despite of the fact that there was COVID and there was no teaching of lectures offline, and now they are suddenly expected to come to colleges and take the exam offline. Can I file a PIL for that matter, and especially say for group of students whose exams are lined up, say next week, and they have no time to run to the court? So can I do that? Possibly yes, when the court feels that yes, these students are underprivileged at the moment, they don't have resources to go to the court. Let us just look into this matter, because this is affecting masses. This is looking at their interests. And I do not have any bona fide, malified intention in filing this PIL. I'm a public spirited person. I actually want to look at the interests of the student, and I have no ulterior motive behind this PIL. So yes, even a letter or a postcard which is addressed to a Chief Justice, say of a High Court, say of Supreme Court, and then the court chooses to take cognizance and convert that letter or postcard into PIL, then yes, it will be treated as PIL. A classic example of this is Rural Litigation and Entitlement Kendra, Dehradun versus State of UP. What had happened in this case? Court had converted a letter raising the issue of unauthorized and illegal mining in Mussoorie Hills into a writ petition. Now you see that there is unauthorized and illegal mining taking place. Who would have gone? Say the people whose lands are getting affected, people who are residing in those areas, who are feeling that this is wrong, but they don't have means and resources to go to the court. Then in that case, somebody who had even written a casual letter, of course, mentioning all the facts and the grievances, then the court will take into consideration and will register it as a PIL. Now let's just quickly see the history of PIL. There are 3 judgments: Husnaira Khatun versus State of Bihar. This is regarding detention of prisoners. It held that this is violative of the Article 21. A prisoner had written a letter to the Chief Justice saying that we are not being treated well over here. Kindly look into this matter. That letter was converted into a PIL and court, of course, looked into it. Next is SP Gupta versus Union of India. This is regarding appointment of judges and the collegium system. This is way back in 1982. This was also taken up as a PIL. And last is Indian Banks Association, Bombay and others versus Devkala Consultancy. This is regarding a tax matter. What had happened over here? Court had held that public interest can also be treated into, private interest can also be treated into as a public interest. If a person who's getting affected, and we see that this problem is not just for this person, but for the entire, say, a class of the society, they can convert that writ petition into a PIL and adjudicate the matter and grant relief to all the persons and not just the petitioner who had come before the court. Now, looking at the landmark judgments of PIL, as I said, MC Mehta versus Union of India, it is not just the Taj Mahal case. He had filed a case for, now this is one of the examples, there are multiple case laws what you'll study in which MC Mehta had filed in those cases. This was regarding Ganga water pollution. In order to prevent pollution in the river Ganga, Supreme Court had held that petitioner, although not a riparian owner, is entitled to move to the court for enforcement of statutory provisions, as he is the person interested in protecting the lives of the people who make the use of Ganga water. Now here, please note that this is for statutory provisions and not for fundamental rights. Court had even extended and said that what is the difference between fundamental rights and legal rights? Anyone knows? What is the difference between fundamental and legal rights?
Fundamental rights are those rights that are given from the right from birth, and legal rights are mentioned in the Constitution, and I'm not able to like
and other statutes as well.
Yes.
So fundamental rights are from your Article 12 to Article 35, which are so intrinsic that if they are violated, you can immediately go to the High Court or Supreme Court. You need not file a civil suit for that in a district court. These are so intrinsic and these are so important that no one can live without these rights, like right to life. If somebody stops you, if somebody provides you with dirty water, suppose government is not looking into cleaning up the water and you are getting sewage water as your drinking water, your right to water, right to life is basically getting violated. You can immediately go to the High Court. You can immediately go to the Supreme Court and say, direct the government to provide clean and drinkable water to us. Yes, not just to you, to your entire locality, to your entire area wherein the dirty water is coming in. Right to equality, right to freedom of speech and expression, right against discrimination on the basis of caste, gender, religion, sex, place of birth, right to education. All these rights are so important that if they are violated, you can seek a higher recourse remedy, go to a higher court, and you need not file a civil suit for that. Legal rights for that matter is, suppose you have Protection of Women Against Sexual Harassment Act. Now this is given under a statute. So this is not under your constitution. But of course, this affects your right to life also somehow, because if somebody is violating your privacy without your consent, then it is violation of your right to life. So this ancillary touches your fundamental right. Or let us say right to minimum wages. Now again, this will affect your right to life, because if minimum wages are not being provided, work is being undertaken by the laborers, but they are not given minimum wages, then they will of course feel that we are unable to live as per the minimum standards laid down by the government. So effectively, when you see all your statutes, somewhere ancillary or primarily, they do affect your fundamental rights. But the statutory rights are basically given under various statutes and not under Article 12 to 35 of the Constitution. Is that clear? Yes?
Yes.
Yes. Now, next is Vishakha versus State of Rajasthan. Over here, what had happened? Court had laid down, so there was sexual harassment. But I'm not getting into the facts. There was a reporter, she was sexually harassed. And then she moved on to the court and said that this is sexual harassment and this is violating my Article 21. Court, at that time, there was no POSH, there was no sexual harassment of women at workplace act. court had laid down guidelines and directed the parliament that we are laying down these guidelines for the meantime. Till the time you do not make a law, these guidelines will prevail. And basis these guidelines only, you frame a statute. So this is judicial review. Monsige was answering to what is judicial review. This is judicial activism rather, not even review. Review will take place of an existing statute. There was no statute at that time. So court had said that we are framing guidelines. Parliament, you look into it, frame law. Till the time law is not framed and enacted, till that time our guidelines will keep on continuing and will be in force. So basis those guidelines, this act was framed. Now this was also because of a PIL which was filed and not simply a writ jurisdiction. Now guidelines, let us now come to the topic, what I'm supposed to speak on today, that what are the essentials of drafting a PIL. Now there are different guidelines laid down by various courts. It can be Delhi High Court, Rajasthan High Court, Bombay High Court, whichever court. I am currently looking at Supreme Court of India, wherein it has laid down certain guidelines as to this is how the petition should look like. Though we understand, is a letter or postcard admissible as PIL and can be converted into a PIL if court takes cognizance of it? Yes or no? Yes,
ma'am.
So then, good. So then you will say, then why are we studying how to draft PIL? Right? Your next question, logical question is, if suppose court is taking a letter also into cognizance, is looking at it and then converting it as PIL, then why are we studying what are the essentials to draft a PIL? The answer to this is every time court will not accept a letter. Sometimes you yourself have to file a PIL, a writ petition in form of a PIL in the court and tell the court, convince the court that yes, this issue is important, is affecting public, is looking at their interests. I do not have any ulterior motive. I do not have any hidden agenda if this matter is accepted by the court, looked into by the court, and therefore this should be heard. That's why it is important for us to understand how a PIL should be drafted. So these guidelines, I'm looking at SC guidelines. Let's just look at these guidelines. Guidelines say that with regard to certain matters, only PIL can be accepted. PIL will not be accepted for each and every trivial matter. Now, what are these matters? As I said, this should be relating to the public and should look at their interests. So logically speaking, people who do not have resources, people who are unable to come to the court, those sort of matters will be coming under this category. For example, now these are some of the examples. These are not all the categories. One is bonded labor. What is bonded labor? Come on, this is English. What is?
Ma'am, sometimes the parents are not able to pay the loan or debt from maybe some people of a bit more privileged or financially stable. So in return of that, they have like a contract that they will allow their kids to work till the debt is clear, and then by this way, the financially stable authority exploits the children also at majority times.
Yes, you are talking about child labor specifically. Bonded labor can be of an adult also, wherein he is made to work erratically. There are no time durations for him to work. He is made to work day and night, basis on the pretext that there is some financial, or can be any other pretext also, that there is some financial loan which he has to repay, for which he is made to work erratically. He is not paid money for that, or he is paid hardly any money for that. So that is bonded labor. Neglected children. Neglected children can be anybody, say a child who is begging on street, say a child who has been lost and is now, many people, I have stayed in Mumbai for some time. What I see over there, many children, say from underprivileged society, come to Bombay with the hope that they will land up in the Bollywood industry, or they will become a star one day. And then they are made to beg. A lot of children trafficking is taking place. Some parents sell off their children because they want money. So they are given some money and those children are trafficked to some other city and they are made to beg over there, or they are thrown into the sex racketing. So all those children, with regard to them, if somebody wants to take up their issue and wants to say in an area, say there is human trafficking going on, including of children. So over there, if somebody wants to fight, but none of those people are willing to take an initiative and go to the court. Even somebody who's not even related, is not residing in that area, can also take an initiative and file a PIL. Say for non-payment of minimum wages to workmen and exploitation of casual workers and complaints of violation of labor laws. Now, this of course should not be for one person. It has to be for a community. It has to be for a public community at large, or public, or say certain people, 50 people, 100 people. That is not a bar, but not just for one single individual. Petitions from jails complaining of harassment or premature release or seeking release after completing 14 years in jail, deaths in jail, transfer release on personal bonds, speedy trial as fundamental right. All these matters, all the rights violation, fundamental rights or legal rights violation taking place in jail can also become an issue for filing a PIL. Then there's petitions against atrocities of women, in particular harassment of bride burning, rape, murder, kidnapping, all such grave fundamental rights violation taking place. Then you have petitions against police for refusing to register a case, harassment by police and death in police custody. Suppose you have lost your mobile phone and you go to police and try registering a complaint there. Or suppose you have lost your wallet. Has this ever happened with anybody, wherein you have lost a wallet and you want to lodge a complaint for lost? Or suppose somebody has pickpocketed your wallet. Does police very readily register FIR? Has any one of you experienced this? Yes or no? Heard somebody undergoing such an experience?
Yes,
No,
ma'am.
Yes. Okay, so what happened with you, Mansich?
Ma'am, the police, first of all, they don't want to launch an FIR under their station, and they want to launch an report, run diary report, which is not at all FIR, but they are saying they have registered under it and they will look counter it. But if there's would have been an FIR, that would be pretty handy, and that would be an as evidence. Yes.
So what you're saying is again partially correct. So FIR would lead to investigation, which the police will do and find who had actually stolen your wallet, mobile, whatever. But simply registering a complaint and taking the complaint on their record, or simply lodging a missing report, is not something on which police will investigate the matter. So of course, stealing of wallet or stealing of mobile phone is not that grave in which Supreme Court or High Court will look into. But yes, other issues, other offenses which are grave, for which police is not registering an FIR, in those cases a PIL can also be filed, and a trend can be shown that in this station none of the police officers registers FIR, and this has been a trend going on. Last year also this happened, this year also this happened, 3 years ago also there was a case wherein it had not happened. Therefore, kindly look into the matter and reprimand these police officers. So a PIL to that effect can be filed in. Next is petitions complaining of harassment or torture of villagers or co-villagers or by police from persons belonging to SC/ST category or economically
Ma'am, I
backward.
have a doubt. Ma'am.
Yes. Yes.
Then in this police case, why one should not file a writ petition under mandamus
You can
instead of PIL?
You can file a writ petition, but difference between writ and PIL is writ, the relief will be granted only to the petitioner who is approaching the court. Suppose I file a writ that suppose some offense had taken place, police did not register FIR when I had specifically given a written complaint. I was the informant, I went to ACP, I went to DCP also. So then what the court will do while granting me relief, that for my case, FIR should be registered. But if I file a PIL, police with regard to that station, or say with regard to Delhi police in totality, then High Court or Supreme Court might say that it will frame some guideline, and it will say every time a girl comes into a police station, FIR should be lodged, say within 24 hours. Something of that sort. I'm giving you a hypothetical example. So the relief would be granted to that section of the society against which the relief is sought, and not to just one person. So you're understanding the difference between writ and PIL. PIL is having a larger ambit. It will affect the masses. The relief given by the court will be given to masses. Whereas in writ petition, only the person who approaches the court will be given that relief and nobody else. Even though there are other people similarly situated, but they will not be given relief over there. Because that girl or that person has gone in writ jurisdiction and not as a PIL, not as public interest litigation petition. Yes?
I mean, which scenario does the relief come first? Like the verdict is being given early.
Giving of verdict, whether this is expeditiously going to get disposed of, whether this will get disposed of first, is not something is related to writ or PIL. That depends on judges working. If a judge is little slow, he takes in more time, he listens to arguments exhaustively, he grants many adjournment, then of course this matter, irrespective whether it is writ or PIL, will not really matter. I am saying what difference is between writ and PIL is the relief which is granted. In writ, it will be granted only to the petitioners who have gone to the court. In PIL, it will be granted to the entire section of the society for which PIL is filed. So for
Yes,
example, when Vishakha versus State of Rajasthan happened, Vishakha did not go for seeking relief only for herself. She said that this violation of fundamental right, Article 21, when sexual harassment is being taking place, not just for me, but for all other women who are working in these organizations and organized sectors at their workplaces, they should be protected from sexual harassment. So that is why a Protection from Sexual Harassment at Workplace Act had come into place. So the relief was not given to her, not just given to her, but to the entire section, which is women who are working at a workplace, the relief was given to them. Yes.
Ma'am, if a writ is only relief is done to me, like in a writ petition, so don't you think that writ petition will be easy to get and that will take lesser time than a PIL?
See, you cannot say that, because sometimes even PIL are disposed of very quickly. Why? Because if something which is glaringly violation of fundamental rights of a particular society, let us for example say that government suddenly decides that all the street vendors and hawkers are to be removed, they will not be permitted to sell their material like this. Only those who are sitting in a pakka structure, which is basically a shop, only they will be allowed to sell their products, be it of whatever kind. Now, this is glaring violation of fundamental rights of street hawkers, because they are not in a position to develop a shop and sell their products. They only have that much resources that they can purchase the vehicle on which they sell off their product, and they are able to sustain themselves. Now, if a PIL is filed for this, I believe that is a better recourse. Why? Because if one hawker goes in form of writ petition, he will be protected, he will be exempted, and he will be allowed to sell on his rickshaw or thela, whatever it is. Whereas if PIL is filed, the entire this rule or regulation will be struck down for the meanwhile, and all the hawkers will be protected in that scenario. So you cannot say that only because it is writ that will be faster adjudication and PIL will be slower in adjudication. That is not the case. Now this again is a hypothetical example what I gave you. But this gives you clarity?
Yes, ma'am. Thank you.
Okay. Now, so there are certain examples, you may read into them. And these are relating to masses. This is not very individual centric examples. Now, next what we have to see is cases which are falling under the following categories will not be entertained as PIL and court will return them back. Now, for example, landlord-tenant matter. Now, this is a civil dispute between two persons. Court will say you have alternate recourse, go before the rental authority, file a civil suit. If need arises, file a normal writ petition, but don't file a PIL for this. We don't have time for individual matters to look into as a PIL. Next is service matters and those pertaining to pension and gratuity. Now, this again is a very individual based matter. Unless and until one institution in itself is having a policy that will not give pension, can become a form of PIL. But otherwise, at individual level, we are not going to treat this as a PIL. Complaints against central or state government departments and local bodies, except in relation to item 1 to 10 above. You see the guidelines, they are mentioned there. If there's something which is at individual level, will not be encouraged. Admission to medical and other institutions. This again goes because administrative freedom is given to institutions. They can frame their own guidelines for admissions, that this much age should be there, minimum age, maximum age, this much percentage should be there. This cannot come as a PIL that let all the students of whatever age be allowed to admit in as a college student in medical colleges. Petitions for early hearing in cases pending in high courts or subordinate court. This cannot be a PIL saying that there's large pendency of matters. Let every matter be heard early. Not possible. So court discourages such matters and court says these should not be treated as PIL. Now looking at the question, who can file a PIL? As I said, any individual or organization on behalf of disadvantaged or oppressed section can file a PIL. What is locus standi? You know what is locus standi or standi? Any one of you have heard the concept of locus standi?
No, ma'am.
No,
Okay.
ma'am.
Locus standi means by what authority? What is your standing? How are you coming to the court? Are you affected by this matter? Are you related to that class? Are you the one who will get affected if suppose there is say land acquisition? I do not even have land in that area. Are you going to get affected by the acts if suppose relief is granted or not granted? Why are you coming to the court? This is locus standi. That what is your standing? Why are you coming to the court? So this concept is relaxed. Suppose I file a PIL that students of so and so college are not being allowed to take exams because they have their attendance lesser than the minimum threshold. Now, if I file a PIL, court will ask me, how are you affected? Why are you coming? Why are those students not coming? I say they are in distress. They don't have resources. Court will say, still, they are at fault. They did not comply with their attendance. Let them come. We will not allow this PIL. But let us assume there is suddenly a regulation wherein all the students were taught online throughout the semester, and then they are told to take exams offline, and college has specifically denied to take any extra classes for those students who did not have access to online education, who were sitting in their villages, who did not have internet facility, where network area were low, whatsoever reasons. So then in that case, if I file a PIL, saying that since students were not given enough education to take an offline exam, and offline exams are rigorous than the online ones, kindly allow students to opt for whether they want to take offline or online exams. Then in that case, court might allow my petition because this is affecting not just one college students, but the entire, say, all over India students. Then in that case, yes, my PIL might be admitted. Then my locus standi will be relaxed. Then court will not say, why are you coming? You are not even a student. Then court might allow because looking at the interest of the public. And any person who is filing it in good faith and has sufficient cause. I don't have any personal interest. I don't have any brother, sister, child, or anybody who is currently studying in a college. And I am not disclosing that to the court. I'm concealing that information, and I have a personal or ulterior motive that if this is allowed or if this happens, then I will be saved or my brother will be saved. I do not have any personal agenda behind that petition. Now, what are the essentials of drafting? What all should one do? Firstly, collect all the documents that are relating to the matter. Secondly, collate those documents. What all are relevant, what all are irrelevant. Leave aside the irrelevant ones, keep with the relevant ones, and they will be used as annexures in your petition. Next is court in which it is to be filed. Know whether it is High Court or Supreme Court. Next is details are to be clearly mentioned as to what is your relief, what is your grievance, why are you coming to the court, why at this stage, why not earlier, why did you come to the court late, is this a continuing offense, is this a continuing wrong which is being done to you, or this was just a one-time wrong. And look at the guidelines of the court which you are going before, either Supreme Court or High Court. What is the format for drafting a PIL? Firstly, you put in a cover page. Now, what is a cover page? You tell him that this is a case information format. This versus this party against this section or this article. It will not be section. It is either under Article 226 or 32, depending on which court. What is the PIL for? Put the heading, put in the lawyer's name, and then that will be the cover page. Second is memo of parties. Memo of parties is basically who's the petitioner, where does he live, what is his age, and what is his email ID or phone number. Who is the respondent, against whom is the PIL filed versus Union of India or government of so and so state. because it will be actually against the state. It cannot be against a private individual, because PIL is basically a writ petition. Writ is always against the state. Writ is not against a private individual. So Union of India, you put in the department, let us say it is regarding tax matters. So Central Board of Direct Taxes, or say Income Tax Office. You put in their email ID and mobile number of any concerned person if it is given on the website. Next is your index. You put in the petition, all the annexures, what are along with that petition. Next is urgent application. This matter needs to be heard urgently because my fundamental rights violation are taking place, or someone else's fundamental rights violation is taking place, and therefore it should be heard immediately within next 1 or 2 days. Next is notice of motion. Notice of motion means you inform the other party, or you inform the registrar general of that court that I have filed this petition seeking this relief. I request you to kindly list this matter at the earliest as soon as possible. Yes. After that, you briefly telling us what is the synopsis and what are the list of dates. For what are you filing this matter? Let us assume we are filing for online and offline exams. The PI list for that. There's a regulation by BCI which says that from May 2022 onwards, all the exams have to take place offline. Despite of the fact that from January to May, all these sessions, all the examinations were conducted online only. And it also says that no extra supplementary classes in any form, either online or offline, will be given to the students. Now, this will be the synopsis. The dates will be mentioned in it. All the dates: on this date, this circular came in, on this date, these lectures took place on this date. Finally, a circular came in regarding examination. This date, another circular came in prohibiting students from taking any extra lectures. On this date, the exams are yet to begin. You put in all the list of dates so that it's easy for the judge to see as to what is your matter. Then you put the main body. You elaborate all the dates, what you had mentioned, and the synopsis. You put in the grounds. Why are you moving to the court? This is violating Article 21, right to life. Article 21A, right to education of children. Freedom of speech. They want to take in off online examinations. Some are wanting to take offline examinations. There's a conflict. So no student should be prohibited from taking offline exam, but others should be given benefit of taking online exam because they do not have, say, suppose COVID is still going on. They cannot travel from one city to the other. They are still under the danger of COVID. They do not have sufficient resources or means. They are in an isolation area. Their entire, say, area is under containment zone, whatever it is. So you put in all the grounds with regard, backing up with the relevant provisions of the law. Then you put in any further submission, any other submission which you have apart from grounds. You put in the averments, and then you seek the relief from the court. It is humbly prayed before this honorable court that this honorable court pass a decree or order. Decree will not happen here. It is an order. Pass an order allowing students to take online as well as offline examination. Second prayer would be pass an order striking down the so-and-so dated notification of BCI which prohibits students from taking supplementary classes. Third will be prohibiting, pass an order quashing so-and-so order by BCI or notification by BCI in which it is prohibiting students from taking online exam. And then you put in an affidavit along with your entire petition that I so-and-so has filed this PIL. I am a public spirited person. I have filed so-and-so other petitions in the past. I have no ulterior motive in filing the present petition. It is only pertaining to so-and-so. I have no malified intentions. This petition is bona fide. I have attached all the relevant annexures. These annexures are true copies of originals. And therefore, so-and-so paras are correct and true to my personal knowledge. So-and-so paras are based on the information received, say from a lawyer. What can be those paras? That this petition is lying before this honorable court's jurisdiction. Court fees has been paid, appropriate court fees has been paid with regard to this petition. All the necessary parties have been included in this present petition. I have no other recourse or remedy alternative than to approach this court. All these legal paras, which are basically standard set paras in a PIL, will be there, and these paras are not based on my personal information. Suppose I am a layman. I don't know personally whether these are correct or not. I don't know the law. So then this is based on the information which I have received from a lawyer, and I believe that he has told me correctly. You put in an affidavit, you sign it, and then you file it in the court. Yes, are there any doubts with regard to this? Till now, what we have studied. Yes or no?
No, ma'am.
Okay, good. Now, next is, what are the grounds on basis which a PIL can be rejected? You did all the essentials, you met all the essentials, but still PIL got rejected. What can be the grounds? One is malicious petition. Actually, there is some hidden agenda and you are filing this petition. Suppose you have filed a petition against the government that so and so circular should be struck down because this is against the principle, fundamental rights, say hawkers and street vendors. Suppose that is the agenda. Now I have filed in a petition where one of the companies of which I am a director had purchased lot of rickshaws and vehicles for promoting street hawking. So then this is a malicious petition. I am somewhere an interested party over here, right? So then in that scenario, or say vice versa, I have currently acquired lot of land and I had plan of building shops on it. And then I am filing a PIL that all the street vendors should be abolished. It does not suit the, the aesthetics of the city to have street vendors and hawkers. Therefore, they should not be permitted to have anything, to sell any product, and only shop vendors should be allowed. Now, this is a malicious petition. I am an interested party. I have already acquired land. I already have plans of building shops. There are documents to substantiate that effect. So that is a malicious petition. That is not in public interest. That is in private interest. It's not a PIL. It's a private interest litigation. So it should not be filed as a PIL. So then in that scenario, it will be rejected. Second is not impleading necessary party. I have not impleaded government of Delhi. The notification was by government of Delhi. I have not impleaded government of Delhi. I have impleaded central government. So of course PIL will be rejected. Central government will come in and say, we have never issued such notification. It is the Delhi government who has issued it. So you sue Delhi government. Why are you suing us? So necessary party is not impleaded, is not made a party to the case. Next is delay from part of the petitioner without any reasons. The notification came 3 years back. I was sleeping till 3 years. After 3 years, suddenly I realized, oh, this was gross violation of fundamental rights. This will be violated. You should be vigilant of your rights or of others' right and move to the court in appropriate time. Next is res judicata. What is res judicata? It means that this issue has already been decided by some other petition. Court has already took a view on this, and then again you are re-agitating this issue. It will be dismissed. Last is misrepresentation and suppression of facts. As I said, I am an interested party. Now, interested party filing a PIL will be dismissed because court will say you have no public interest intentions over here. This is a private litigation. What you are wanting, you are having ulterior motives. You are not coming to the court bona fidely. You have malified intentions. Yes. Now, some of the examples of misuse of PIL, wherein it was not in public spirit. First is that there was this one party who had put in their manifesto. Now, manifesto is basically the promises is done by the party before elections, that if we come into power, we will provide this to you. So one of the conditions in the manifesto was that we will offer cash transfer. So instead of all the online regulation or transactions, we will allow huge bulk of cash transfers also. People will not have to look at some limits, say 50,000, 1 lakh, 2 lakh, whatever. We will allow even say 50 lakhs transfer also. So somebody filed a PIL and court said that we find no merit in this petition. We therefore dismiss this writ petition. That if in manifesto someone is saying that they will offer cash transfers, this is not something which will promote corrupt practices. This is in their manifesto. Once that policy is made and there are some statistics to prove that yes, it promotes corruption, then we will look into the matter. Right now, it is all in future in air. Possibly that party will never get elected also, will never come into the power. So it rejected that PIL. Another case is wherein opening of the doors of Taj Mahal. Somebody had filed a PIL that there are 22 doors which are closed. There are 22 rooms in Taj Mahal which are closed. Those doors are closed. kindly open those doors. So court said tomorrow you will come and you will say, open the doors of our chambers also, open the doors of here also, there also. This does not make sense. It is appropriate and discretionary of the Taj Mahal authorities. If they want to keep those rooms closed, for which doors have to be closed, let them close it. It is their discretion. We do not see any merit in this PIL. Now, next is there is a regulation in Delhi wherein all the vehicles which are more than 15 years old, run by petrol, and all the vehicles which are 10 years old, more than 10 years old, which are run on diesel, they are prohibited in Delhi. So somebody had filed a PIL saying that such banning of these 15-year-old petrol vehicle and 10-year-old diesel vehicle should not be there. So Supreme Court on 17th May very recently held that had imposed a cost of 8 lakh rupees on the petitioner and saying that this PIL was frivolous and ordered the registry, told the filing section that, listen, next time this advocate files any PIL, please do not list it before us. Please list it before some other bench. We don't want to hear his PILs. So this is a very adverse impact for that advocate if you see. So such acts are also discouraged and highly, you can say the court rebukes such people also sometimes. Imposing a cost of 8 lakhs is no less. Because court felt that in Delhi there is a lot of pollution and this is an appropriate measure in order to curb the pollution. Now this again, I'm not going into the merits whether it is correct or not. The court held so. Now you all know Juhi Chawla's case. Juhi Chawla went to the court stating that 5G should not be introduced because they have a lot of transmissions which will affect the human health and it is not good for living healthily on this planet. So court what had done had imposed a cost of 20 lakh rupees on her and said that this was just a publicity stunt. You wanted media's attention. That's why you have filed this case. We do not agree with your reasons for filing the PIL. So these are some instances for misuse of PIL. Now, as Rukshat was asking, and I think Monsij was also saying, what is the difference? Or I believe Divya, I don't know why is Divya, I think it's some boy who's sitting behind the computer. What is the difference between PIL and writ? Why do we go for PIL or why should we go for writ? In what stages, at what instances should we go? Now the difference is, firstly, PIL can be filed by any public spirited person. Even if you are not affected by that offense or by that incident, you can file a PIL, whereas in writ, you need to be the affected party. Second, in PIL, locus standi concept is relaxed. Why are you coming? How are you affected? What is your interest in this matter? If suppose we give you remedy, it will not even apply to you. Why are you coming to the court? That concept is relaxed. Anybody can go and file a PIL. In writ jurisdiction, only those who are affected, only those who want that relief from the court will go to the court. And court should prima facie be satisfied with the contents of PIL for faster dispensation of justice. Whereas in writ, the evidence and regarding rules and procedures are strictly adhered to. Court will look into as to whether have you attached any document that you are saying that you were not promoted in this institution, you have filed a writ petition for your promotion. Were you even employed in that department? So it will look into the documents, it will look into the proofs, and then will grant appropriate relief. Now, what is the conclusion of today's session? Firstly, PIL is a very effective tool in order to seek justice for the underdeprived or people who are unable to approach the court. It's an important tool to protect those rights of those people. Second, rules regarding PIL are very simpler. You don't have to adhere to lots of nitty-gritties. On the basis of newspaper report also, you can go that newspapers are publishing it. I am not knowing any relevant circular. It is not in public domain. Call the department, ask the department, what do they have to say on this? It is in public knowledge through newspapers that so-and-so banning has taken place or so-and-so demolition of the, say some monument is going to get demolished. This monument is preserving the heritage of the city. This is relating to the archaeological site and therefore it should not be demolished. So this is a PIL. This affects public. This affects, it has some religious sentiments attached to it. Therefore, it should not be demolished. So over there, documents and evidences are not very, very important. Court itself will look into the matter, will call appropriate concerned people and ask them and then accordingly pass a relief, grant a relief. Several instances have taken place where people have tried to misuse PIL and they are then penalized by the court either by way of cost or either by way that they should not, their PIL will not be entertained before certain courts. So one should be using the tool of PIL very effectively and should not misuse it. Thank you so much. Are there any doubts? Please let me know. I'll be happy to address them.
It will be helpful if we can provide some sources.
Sources of what?
In this PIL. And example.
Some more examples of PIL you want?
Yes, ma'am.
So as I said, if you have seen those cases given in the presentation, SP Gupta, then MC Mehta, then Vishakha guidelines, then very recently I've given some examples of misuse of PIL, Juhi Chawla case, Taj Mahal case, all those cases. When you see, you'll understand. Now over here, I'm not trying to tell you that what are the matters on which you can file PIL, but I'm trying to give you a gist as to what PIL is and under what circumstances is it not encouraged. So in your daily news also, as I said, marital rape can also become an issue for PIL. In Delhi High Court, it was a writ petition. It was not PIL. There were 4 different petitioners who had gone to the court. Court had clubbed those matters, and then that matter was heard in totality by all 4 petitioners and the respondents.
Then
it can be regarding anything. It can be regarding right to life, right to equality, right to freedom of speech and religion. It can be regarding anything. Yes, Divya.
Ma'am, if I was affected in a certain case, and it is very individual, and in that same case, 5 more are affected, then what should we approach? Then we should go with writ petition or we should go with PIL?
You are saying there is one person who is getting affected over here?
Yes, and in that same case, 5 others are affected.
Okay.
And it is very
individual. 5 people are affected, then the matter also has to be looked into. What is the merit regarding what is the matter about? Suppose 5 people are getting affected, it will not come under community at large domain. It is not public basically. 5 people, hardly 5 people. So court might discourage it as a PIL. Then it is better to file a writ petition. File a writ petition by one petitioner, and others along with those other 5 people will also be tagged in the same writ petition as petitioners.
And then what is the similarity between a writ petition and PIL?
Similarity is PIL is also seeking the same relief as writ petition would do: mandamus, certiorari, quo warranto, prohibition. So all those, whatever relief you usually seek in a writ petition, which is basically against the violation of your fundamental rights, similar relief you seek in PIL. But the PIL relief is applicable to all the persons of that community or the public. Writ petition, the relief is only with regard to one person.
Ma'am, I have just a question. Can a judge can I just simply ask someone or just state someone you can't just file a PIL in front of this bench? Or can judge sometimes just curb the rights of a person to file a PIL or any rights?
No, that is why the judge did not say that do not file PIL in every time in future, or will impose costs every time you will file PIL. Judge said we are disgusted because we don't have time to entertain bad PILs. We have a lot of other work to do. We are disappointed. We do not agree with his contentions. Possibly, it might be possible that that advocate would have filed earlier petitions also, earlier PILs also, which would have got dismissed one after the other. So that's why judge said, don't list his PILs before us. Let it go before some other court and say Supreme Court, some other bench, but not to us. We are not willing to see frivolous litigation.
Just another question. I just would like to add the PIL you just mentioned about of Juhi Chawla. Okay, I know she's a public figure, but the PIL she registered about the abolition of 5G and other things, that was a valid PIL according to me, as because it contains lot of frequencies which are which can harm the nature and the birds and also the livestock because of these frequency matters.
Right.
So why does that PIL just got cancelled or not taken into condition?
Right. So
Can you just light upon that fact of that
as I
PIL?
said, many
Ma'am, but
PIL.
it is proven that no frequency is going to be affect. Ma'am, it is proven that no frequency is going to be affect any animals or any birds.
Statistically they could not prove it, because in order to prove that you need some time to pass, you need to have some figures, you need to show that even though there was this transmission, some people were affected, some were not affected, or all of them were affected. So statistically it is very difficult to prove. It was, I believe, in my opinion, it was very subjective. Argumentative arguments would have been led in over there, and court was not convinced. So that's why, since court was not convinced, it can always become a matter of debate that yes, this is bad for health, this will affect the health. But then if statistically one is not able to prove, then it is not a good PIL. Court will not grant relief. Court cannot grant relief basis their hinges. They feel that yes, I also agree, I also feel this might affect us in future. Basis that court cannot grant relief. Court has to base their reasoning on some substantive proof. They have to rely on some statistics. They have to rely on some data which proves that yes, this is against your health.
Ma'am, the court just denied the PIL on the matter that you are a public figure and you are just doing it as a public stunt or just for the need of publicity. But that is not a correct way of dismissing any PIL, right, ma'am?
That's also because there was something called, when her hearing was taking place, one of the fans had got into the, it was through VC. One of the fans had got into the hearing time and then started playing her songs. So I believe it was coming up with some background also. And I am sure court would have given certain reasons, not just this statement, but would have dismissed it on some other also, that she was not able to prove it basis on some statistics. And otherwise, when we see this as a holistic PIL, we feel that she has done it in only for publicity stunt.
Ma'am, in the slide, you just said that anyone can file a PIL, right? So eventually, if I'm filing a PIL, like for the conduct of online exams, okay, like my father can file a PIL, but eventually I am his son, okay. So that can't be a form like you are doing it for a own interest or your for own needs, because anyone
That
anyone
should
can
not,
have.
example what
Yes,
I
ma'am.
gave in was not, I would say 100% correct. But what I wanted to tell was there should not be any personal interest of mine involved in the matter. So
Like,
personal interest can be, suppose I have enrolled for some other course, say LLM course and not LLB course, and then I am challenging this matter. So then also, if I am the aggrieved party, court might entertain it. But court if feels that suppose I am a checker, I am an examiner, and it is burdensome for me to check offline exams than online ones, because online exams there are certain softwares which check the papers automatically. And that is my motive, that I should not go for checking and I should not be undergoing that labor. So then in that case, yes, court will say you have a personal agenda involved in this.
yes,
Now my
this
example
one is, yes, ma'am.
stated
This example is like pretty correct. Thank you, ma'am.
okay. Are there any other doubts?
Interns, you can even type her in the chat box if you are not willing to unmute yourself.
I believe there are none.
Okay, so as all of you don't have any further doubts, I would like to proceed with the vote of thanks. I, Riddhi Jindal, on behalf of Team Law Internships, would like to extend my heartfelt gratitude to Ms. Manasi Bhushan ma'am, who took out time on Sunday from a busy schedule and interacted with you all today and taught you how to draft a PI. It was a very informative session, ma'am. Thank you so much for joining today.
Thank you.
Thank you,
I
ma'am.
also had a great
Thank
time.
you, ma'am.
Good
Thank
luck.
you, ma'am.
Thank you.
Thank you, ma'am.
Thank you.